Honourable members, the ayes are 61, the noes are 59. Part 4 as amended will stand part. The question now is that Part 5, which is debate on clauses 175 through to 316, stand part. I call the Honourable David Parker.
Mr Chairman, this is one part of the bill where I'm going to speak in favour of some of the standardisation of rules that apply to different agencies. There are, as the Minister has previously said, a large number of slightly different legal tests that apply to the powers that are search and surveillance powers under various pieces of legislation. And to give you an idea of the breadth of legislation, I'll just read out a few of the different acts that we're amending: the Agricultural Compounds, the Animal Products Act, the Animal Welfare, Antarctic Marine Area, the Antarctic Environment Protection Act, the Aviation Crimes Act, the Boxing and Wrestling Act 1981, which I had completely forgotten about until I read it in the schedule. And the list goes right through: the Drift Net Prohibition Act, the Land Transport Act, the Trade and Endangered Species Act, and the list of acts that are being amended so that the powers and the protections that are surrounding the powers that these different organisations have are standardised. Runs to 8 pages, from page 11 to page 19 of the description at the start. That's just the list of sections that have been amended, and the relevant sections that are amended run to a large part of this very long bill. So it's good that we're standardising these protections and rules that surround the use of search and surveillance powers that have been conferred by Parliament on all these different agencies. And I think that's a good thing. But it does, again, highlight the fact that we've got this inconsistency that we're actually not doing it for the Serious Fraud Office. Mr Chairman, one of the benefits of the committee stage of the debate is, as members, we all learn things. And I've found this debate quite interesting. I've learned some things, and it's actually helped me and my colleagues in our thinking as to where we think the line should be drawn in respect of production and examination orders, not just for the Serious Fraud Office, but for the police as well. And we've also listened to the debate that's been outside of this Parliament, including the opinions that have been expressed by the Media Freedoms Committee. I thought that the editorial from the Herald, which I suspect was written by Tim Murphy, I don't know that to be the case, but I know he's chair of the Media Freedoms Committee on behalf of the members of the media. He will have had a hand on it. I found it quite persuasive. And I think I've got to the position where I can accept that we need the Serious Fraud Office to have some of these powers that undermine the right to silence by allowing them in situations relating to commercial transaction and business records that show complex fraudulent transactions, that they need to be able to unpick them by going to the people that hold those records and saying, please give us those records, please explain how those records, what those records mean, and it effectively allows those people to be released from their duty of confidence. And I agree that's appropriate, and I also think the police should have that power in that same context. I'm uncomfortable with the police having that power in respect of the criminal investigation of the primary suspects in a crime, because it undermines the right to silence. The people who are forced to give evidence are likely to lie anyway, so the reliability of the evidence they gather is not good. And that's one of the reasons why traditionally we've not forced people to answer, because when they're forced to answer rather than when they answer voluntarily, they are more likely to lie when they're forced to answer. And as well as that, we undermine this relationship between the police and the public if we force members of the public to give evidence against their loved ones. It's very difficult. In fact, it's not that long ago where, in respect of charges against a spouse, the other member of the family, the husband or wife, wasn't even competent to give evidence, even if they wanted to. And the public interest, and that was a ridiculous law. And eventually Parliament changed that and said that they should be competent to give evidence against their husband or wife or partner, but they should not be forced to. And yet what we're doing with production orders and examination orders is going that step further and say people must answer. And that undermines the relationship and the relationship between the public at large and our enforcement officers. In the end, it places those enforcement officers at one place or another, Mr. Chairman,
Honourable David Parker.
in greater danger as they go about their duties, which they go about in order to protect us. And I don't want to undermine the relationship of trust and confidence and cooperation which lies behind the way in which we have public interaction between law enforcement officers and members of the public. Most information that law enforcement officers get is through that relationship of cooperation, because people know, they see it as their civic duty to ordinarily cooperate with the police authorities or the other arms of the state, whether it's the Ministry of Agriculture looking into foot and mouth allegations, or whoever it is. The public feel an obligation to cooperate with the police. That obligation is undermined, or that sense of obligation, that sense of social duty is undermined if people lose confidence in the police because they're forced to answer questions about their loved ones. They're put into the difficult position of telling the police information about their son or their daughter, their husband or their wife, their partner, their best friend. At the moment, people can say, "No, I'm not going to say anything." They can't lie, but they can say, "I'm not going to say anything." And I think that listening to some of the contributions from New Zealand First and the Greens in this debate, but particularly the contributions from New Zealand First, I've been quite moved that they're aware that this right to silence, which we have in New Zealand, is really important. So I think where I've got to in this debate is that my own understanding of these issues has improved, and I've got to the point where, in the business context, fine, I think these powers are at times necessary. But outside of the business context, I don't think they're appropriate, and I don't think we should be conferring them in that context. It's interesting, when the former Police Commissioner Howard Broad first came before the Select Committee, he, and indeed before that to the Cabinet, and I was in the Cabinet at the time, I can remember Mr. Broad saying that he didn't think the powers of compulsion that are conferred by production orders and by examination orders are necessary for the police. He thought normal investigation techniques, which have stood the test of time through the 100 years that they've been in existence, and those are the powers they've operated until now, sufficed. So I think that's the position that I'm getting to. Having said that, I do agree that the standardisation of powers across these various agencies is desirable. I think it's too confusing for everyone involved to have legal tests which are in tiny little ways different from one agency to another.
Call Charles